read at least some parts of the judgment, and I thought it's useful because it's a kind of a concrete application of things which we looked at in the previous session, and it's useful also because I think reading a judgment in total, it gives you a sense of of the course as a whole, literally, right? Because you're looking at, I mean, look at the various provisions being touched. We're looking from 14, 15. We look at all of them a little more. 21, 17, 23, right? So looking at all those provisions, seeing how it applies in this particular context, and you're seeing uh, how they're violated. Right? That's put very very broadly, but more specifically, maybe if people can, we can begin with the most, I think the which should be the fundamental question which lawyers don't often start with, which is the question of who is Sukanya Shanta, right? Who is this person in whose name we have this judgment? Anybody wants to just quickly give a shot at it? It's a case named after her, and the case, of course, I mean, just in two lines, right? The case is to do with the practice of caste discrimination in prison, as specific as that, right? There is caste discrimination.
Feel free
Sorry,
to unmute
sorry,
and sort of share your responses, else type don't.
could she be a writer? Is she a lawyer? Is she a progressive thinker? Is she a women's rights activist? Is she a teacher? Sorry, please go ahead.
I think it said she was a journalist.
Thank you. Yeah, she's a journalist. The journalist. Again, it's an important point because you go back to our discussion of the Bakshi piece, right? He talks about a way in which, for social action litigation, the the media and the litigation field or lawyers really come together in terms of taking forward constitutional protections. Sukanya Shanta is a journalist, and she did actually a very very moving story. I mean, if you get a chance, please do read it on the question of, again, as I was saying, caste discrimination in prisons. She starts with the story of this young man. I think he's 23 years old, if I remember, and he's in under trial, and he gets taken in because his first job as an electrician, right? He's a member of the Dalit community, Dalit Dalit community, or lower among the OBC communities, and he gets taken in for he gets accused by the employer of stealing some equipment, and since he's the youngest fellow, the chap who's most recently joined, uh, put on him. FIR is filed. He gets arrested and taken to jail. And he describes this, right, and this is what Sukanya Shanta describes. When he's in jail, the first question is asked is, "What is your caste?" And he mentions his caste, which happens to come within the more depressed communities, depressed castes. And immediately he's put to work doing the cleaning in the jail, right? In terms of cleaning of the toilets and the washrooms, etc. Initially, he thinks that's the nature of life in jail. Everybody has to do cleaning. Then he realizes that's not so. He's the only one doing the cleaning. Rest of them, or most of them, are not cleaning toilets. And then he realizes that it comes down to this question of a caste-based practice. And it's quite an awful description, actually. Then at one point in time, one of the manholes gets blocked. And so the warden basically tells him that, go get into the manhole and clear it. And he describes that the manhole is like blocked, it's filled with feces, and he has to go in to open it out, right? Or to release the blockage, as it were. And he says, I mean, he describes when he gets out. Of course, he gets out because there's no case against him. He gets acquitted, etc. He says that memory never left my head. Question of being in that manhole to try and clear the manhole. And then he says something very poignant. He says, "See, my father moved from the village, right, to the city, basically to escape a caste-based practice. And here I was, back back doing a caste-based occupation, which is the cleaning of the toilet." And said that it's and that's the way she begins that story, right? And it's a very moving story because one is, of course, these narratives, right? And then she makes a very interesting connection. She says, this is a practice which is there in jails. Is there a legal backing for this practice? Or is this practice happening in contravention of the law? I've just mentioned the various provisions, right? Obviously, this practice is in contravention of your right to life, your right to dignity, your right to non discrimination, freedom from discrimination in terms of caste, etc. But in the prisons, the law which governs is not the constitution. The law which governs your everyday practice, right? Everyday practice are the prison manuals and the prison rules. And that's what governs. And again, she pulls out a range of these prison manuals, uh, Sukanya Shanta, that is, and she finds that prison manuals come in the 1960s or 1970s or way post independence still have uh, in them the notion of a caste based practice. Prison manuals specify who's to do the cooking, Brahmins are to do the cooking. Prison manuals specify who's to do the what they call conservancy, what they call manual scavenging, what who's to clean the toilets. They specify that which castes are to do the cleaning of the toilet, right? And then she makes that connection. She says, when this guy is asked, this poor fellow is asked, what is your caste? The reason for that, the reason for asking that, because prison is a caste based system. It runs completely on caste, right? And you need to fit within that hierarchy, and that's the reason you get asked your caste, and you get slaughtered in one particular slot, right? And this is shocking. I mean, I think it's completely shocking. I'm sure all of you think it's shocking since you're a part of this class. I'm sure everybody thinks it's shocking. But the point she concludes by making, she says groups which have worked on the question of prisons and prison reforms have never taken up the issue of caste in prisons. Never. Right? Again, it's an indictment, and it's an indictment which I think many organizations, including PUC, are allowed to bear, right? Saying that, here is a critical issue which Sukanya Shanta's point is you never dealt with. Not Sukanya Shanta's point, yes, correct. Her point is you never dealt with it. You never acknowledged the question of caste in prisons, including progressive groups, right? So it's a finger pointed at, I think, all of us as well, right? I mean, all of us. I'm not saying all of us, but many of us saying, hey, even if you're talking about prisoners' rights, have you got in your head the fundamental point that in Ambedkar's understanding, right, you think of caste as a graded hierarchy with what he calls an ascending scale of reverence and a descending scale of contempt, right? And the ones at the bottom is really the brunt. And think of I mean, if your prison administration is run on the basis of caste, then what in effect it means is if you happen to belong to a Dalit community, you're the one cleaning the toilet. If you happen to belong to a Brahmin community, you have a range of privileges which accrue to you based on nothing other than your caste. If this is not a violation of the constitution, it's very difficult to say what is a violation of the constitution. Right? The idea that you the constitution deals with you as an individual human being, right? Not based on your caste. But the prison administration is based fundamentally on the question of caste. The world outside has changed, right? The world outside has changed in terms of the constitution has come in, you have a range of protections which people have against the question of discrimination. But this is the reality as far as prisons are concerned, right? So she writes this article, and it's quite a actually you should see the interview as well. I mean, I had a chance to read it very recently, and I was just telling Suresh that it's such a tragedy. I only read it recently, this entire judgment, and in such a tragedy in terms of, I mean, I'm glad I read it finally, and I hope you all feel the same thing and say, I'm going to read this judgment now because it's you have to read it, right? It's a very very important judgment to read to understand the nature of the world we live in, as well as to understand what can be done about it by people who are conscious or people who feel offended or shocked at what they see around them. Right? Sukanya Shanta is one such person. And I think, of course, she had a very strong sense of right and wrong, and this really offended, her sense of right and wrong. And I think it will offend all our senses of right and wrong. And the story she begins with is very moving. Huh? And I'll send that. I think I can just send the article to you. Maybe I'll. Shantan, do you think I'll just send it now itself? Or we'll do it later?
You can send it to me and I can.
I found the link. I'll send it now itself. And the guys who can just read it. Unless you want me to open it out now, is that better?
Yeah, I
Or
can also do that.
okay, I'll just do that.
I'll just open it.
We'll just spend quick 2 minutes looking at the article, and then we'll.
You're able to see my screen?
Yeah, but not the article. Okay, now we got it. Yes. Yeah. Go down. Yeah, go down.
Yeah.
You're not able to go down, Chandan, or it's stuck. Hello, are you there? Can everybody else hear me, or only?
Yeah, you're audible.
Yeah,
Okay,
we can hear you.
okay. Shantan is the only one we can't. He seems to not being able to get. Anyway, okay. When he opens it, it opens. Don't worry about it. But I want to just show you the article so you can read it, right? So no worries about that. Okay. Let's move on from here to the case itself. Yeah. Um, okay. The point about the article again, right? Yes. This is the point. There's a very nice interview with her about why she did that particular article and the range of articles on life in prisons, right? And she makes the point that, see, end of the day, why does a journalist write? Journalist writes because you want to be able to change the world that you live in. You're not only interested in writing for the sake of writing, especially in issues such as this. You're writing this because you want that change to happen. And she says, I mean, I wrote that article. 2 years I was seeing what's happening. In 2 years, there were two states, I think Rajasthan and Goa, in which a couple of the rules got changed in the prison manual. But otherwise, life continued as normal for every other state in the Indian Union. At which point she thought to herself, and she said it's a very nice discussion actually, because journalists have of course, the question of journalist ethics, right? You don't get involved with your source or with your story, right? You're doing a story. You have to maintain a professional distance. You have to be able to say that I'm different from my story, and you have to be within quotes objective, see all sides of the story. That's the fundamental of being a good journalist. But she says this case, I just felt I had to do something about it. I just felt I had to do something about it. And you can imagine, because such a moving story, I recommend all of you read it, right? It's a very moving story. And so then she decides to file a case challenging the various provisions of the rules which discriminate on grounds of caste. Again, the question I asked you, among the questions which we asked, first is who's Sukanya Shanta. Second question I think was uh, on how do you know there's discrimination based on caste in jails? Very important question again. And because a prison is a closed institution, right? It's not a place where people have everyday access. It's not that all the stories of prisons get out. It's very difficult to get a sense of what is going on in prisons. And if you look at the petition itself, again, very, very interesting. It doesn't rely on what you call affidavits to document the reality of discrimination based on based on caste. Again, I'm relying purely on the judgment. Will be great. Actually, great point. If you get a chance, we go to the lawyers, Dr. Murlidhar and Disha Vadekar, and see if we can get the copy of the petition, right? And what are the various documents they submitted, right? Then they might very well say that, of course, we submitted a range of affidavits which documents uh, the fact that prison is a caste-based administration, right? The prison administration is caste-based, and it's continued without a change, right? From colonial times, from colonial times. Let me just get my yeah. But the point, the if you read the judgment, right? Again, what you the sense you get is that the case on discrimination is made based on the rules which are there in the prison manuals. That's it. Right? The case on discrimination does not rely. I mean, in terms of the reported judgment, again, I may be wrong in terms of what the petitioner submitted, right? But in terms of reported judgment, it relies on the prison on the rules in the prison manual itself, right? What are those rules? I mean, I think it makes sense to read a couple of them just so you get a sense of what is it one is really talking about. So let me just share my screen and open the judgment for you. Yeah. Again, this is a Justice Chandrachud judgment, and I think if you look at the table of contents, you get a sense of the way the entire judgment is really structured, right? Uh, you first give a broad sense of what the Constitution is, what is the promise of the Constitution. Then you look at each of those articles, right? On the basis of which you're going to come to your conclusion, which is I just said 14 equality, 15 non-discrimination, 17 provision of untouchability, 21 life and dignity, 23 provision of forced labor. Right? Then they go into the question of discrimination based on caste in the pre-colonial era. Then, in particular, the colonial interventions. Right? What did the colonial intervention do to with respect to the question of discrimination of the criminal tribes as well as caste discrimination? Again, there's a lot to here which we should talk about, but I don't know how much time we'll get. We'll see. We'll see how much of this we can get into. Then the entire question of what is the jurisprudence on social protection post-independence India? This is what I wanted to get to. What are the provisions one is talking about? As we could say, what are the impugned provisions? Uh, which is the prison manuals and the legacy of discrimination. And then look at the current intervention. This is again very important. The model, note it as we're speaking. We have the Model Prison Manual 2016, which is 2 years after the Modi government comes to power, and then there's the Model Prison Correctional Services Act 2023, right? And again, if you think rights as progressive and how rights develop over a period of time, then ideally speaking, even if the 16 prison manual does not encompass or does not deal with the question of discrimination based on caste, the 23 should. Right? 23 should. That's the way you think about it logically. Then yeah, this is the last part, of course, is the conclusion direction. Right? What are the conclusions the court finally came to, right? That's where we need to get to. But to get to the conclusions and directions, you have to go through the reasoning, and very important for us, right? First, we'll go over what I want to take you through is the impugned provisions or the 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 yeah. So there's a Prison Act of 1984 with rules under it, right? And again, one simple point, right? I mean, why do you have so many states with their look down, right? We say that prison manuals, the Uttar Pradesh manual, West Bengal, Madhya Pradesh, Andhra Pradesh, Orissa, Kerala, Tamil Nadu, and Karnataka is here as well. Bombay, Kannada, Himachal. Okay, so you get a range of prison manuals which I referenced, right? And we're not going to go over all the manuals, but you get to give you a broad sense, right? Uh, on couple of them. Somebody just please read this Uttar Pradesh jail manual and look at the date, 2022.
The Uttar Pradesh Jail Manual, 2022, Section 158. Remission to convicts on scavenging duty, subject to good work and conduct in jail. Convicts of the scavenger class working as scavengers in jails, or convicts who, on administrative grounds, it is not found expedient to promote to the grades of convict officers, shall, though they may not be appointed convict officers, be titled to receive ordinary remissions at the scales sanctioned in the preceding paragraph for convict night watchmen and convict overseers, respectively, with effects from the first day of the month following the one on which they would, but for this rule, be eligible for promotion to those grades.
Yeah, if you just again the point here again is what is going on is some form of a classification, right? And classification of prisoners based on the question of those of the scavenging class and the others as it were. Just look at the couple of the other rules. We won't get a chance to look at all of them, but just a couple of the other rules we'll look at. Bengal, okay. I want to look at if you look at this, right, on food, food shall be cooked and carried to the cells by prisoner cooks of suitable caste under the superintendence of jail officer. Again, when this Bengal does this, 1967, right? And look at how detailed it is. The barber should belong to the A class. Sweepers should be chosen from the method of the Hari caste, also from the Chandal or other castes. By the custom of the district, they perform similar work when free, or from any caste if the prisoner volunteers to do the work. Right? Again, if this is not caste-based administration, what is, right? This is even more wonderful. Selection of cooks. Any prisoner in a jail who's of so high a caste that he can't eat food cooked by the existing cooks shall be appointed a cook and be made the cook for the full complement of men. Yeah, in Madhya Pradesh. Yeah, I'm not. The other grouping. Okay, one is of course caste. The other is the entire question of the tribe, right? And the denotified tribe, which we'll look at in a little while. Denotified tribe who comes within the framework of the Habitual Offenders Act. We'll look at that anyway. Huh. This is wonderful, isn't it? Allowance for caste prejudice in the Andhra Pradesh prison rules. Just read that.
Allowance for caste prejudice. The prison tasks, including conservancy work,
Yeah, shall we please go on? We will lose Tilo.
regard to capacity of the prisoner, his education, intelligence, and attitude, and so far as may be practicable, with due respect to his previous habits.
Interesting, right? I mean, there's actually a provision that says an allowance for caste prejudice. I'm like, this comes in again 1979. So how is it that the Constitution completely bypassed, right? The the question of prison administration. How was the prison administration even allowed to use language such as allowance for caste prejudice when you have Article 17, prohibition of the practice of untouchability, right? As specific as that, as far as the Constitution is concerned. So again, the point being, the big question, of course, is how does the Constitution enter the the gates of the prison, right? And that's the huge challenge we're seeing here. I mean, each of the rules I'm reading, we're like, wow, what is the world that is one is living in, right? And the wandering tribe. Okay, just one last reference point. Please keep it in mind. One is the question of caste. The other is we've seen the language of wandering tribe, the language of habitual offender, the language of member of a criminal tribe. Right. That's the other kind of a classification, which you can see at work in the prison. Right. So there's obviously it's as crystal clear kind of shall we say uh, we can say that crystal clear kind of classification on grounds of caste communities, right? The Babu communities, the Mehtar community, etc. And that's one kind of classification. The other is classification in terms of the occupation, which people are used to, as it were. And the third is the classification basis of the entire question of tribe, right? The wandering tribe is classified differently, the criminal tribe or the habitual offender, right? And so the question you're asking of is these forms of classification, are they valid? Again, when do you ask the question? You ask the question when you test these, I think again, provisions which are I think quite shocking, right? Quite shocking from a constitutional perspective when you test them within the frame or the language of the constitution. That's the petition, right? What is the petition doing? Taking these realities of rules which are based on caste and testing it against the frame of the constitution. What is the frame of the constitution you're testing with, right? If you ask that question, let me just this is the Sukanya Haldar article, but we leave that for now. We'll get to the constitution. Yeah. 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 If you're testing it against the language of the constitution, what you're testing it is with respect to the fundamental rights chapter, right? And again, this is just to refresh your minds again. You're testing it with respect to 14, which is equality before the law, 15, prohibition of discrimination, 17, prohibition, abolition of untouchability, 21, life and liberty, and 23, the prohibition of traffic in human beings and forced labor. These are the provisions against which you're testing these prison manual rules, right? And again, if you guys remember, when we looked at 14, right? What's it called? Okay. Which is the equality provision. State shall not deny to any person equality before the law or the equal protection of the laws within the territory of India, right? And if you remember what Sila took you through, right? 14 today has become what you'd call a kind of a bit of a technical provision where what you have to demonstrate to pass the test of 14 is that your classification as an intelligible differential between, say, uh, between people belonging to a particular caste and people belong to another caste. The classification is an intelligible differential. It doesn't It's linked to an objective which you seek to fulfill. Right? If you can show that, then your classification stands valid. That's the equality test. Right? And there's another, it's another debate altogether, but I'll just maybe briefly make that point. Uh, this again, it's a very important judgment to read uh, because it takes on this logic. Oh, what do you think of Article 14? Right? When you say equality, what do you mean by equality? It's a very important question because if you noticed, sorry, why is this happening to me? Yeah, if you notice when we did the provision with Sila, we went into the classification test, right? And so the argument which this judgment is making is when you say equality, it's a kind of a substantive commitment of the Constitution. It's not purely on the question of classification alone, but it's something which is about the deepest values of the Constitution, the substantive equality, not just formally, right? And so that's one kind of a frame they use. The second frame they use again is a very important kind of a basically technical point itself, which is why do you classify on grounds of caste? If you're in prison, why? Okay, go back to a question. You're in a prison. Why do you want to have a prison manual and prison rules? You have prison manual and prison rules to prevent escape, to ensure that the life of your convicts under trials is safe, to ensure that this within the constitutional sense, there's some level of quality of life you maintain to all persons. That's your objective. If your objective is that, why would you classify on grounds of caste? If the objective of a prison manual is to prevent escape, why classify on grounds of caste? Why is it relevant that a person belongs to the sweeping community or the scavenger community? Why is it relevant? Is the question which the court asks. And the court comes to the finding that 14, there is no intelligible differential. If you're making a difference on grounds of caste, it and the purpose is to ensure affirmative action, there's a certain connecting link. The objective is a valid objective. In this case, you're classifying people on the grounds of caste, but the objective is to ensure that there's no escape in prisons. There's no link. If you want to carry out administration, you can carry out your administration in prison without reference to caste. It's absolutely irrelevant. Would be the is the argument the court puts forward, and therefore they argue that these rules violate Article 14. Right? Then we'll look at 15. Again, what is 15? I'll just share the screen again so you have a yeah, somebody just read 15.1, please.
The state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth, or any of them.
So again, right, what is this question of discriminate on grounds of caste? That's the question the court addresses in this particular case. Again, yeah, I'll make the point, and I've given you the outline of the judgment, so you can actually go with the table of contents. You'll find the paragraphs and the pages I'm referring to, right? What is discrimination on grounds of caste, and how do you understand what is discrimination on grounds of caste? What gives meaning to the term discrimination? If you read that one line which we just read out, there's not much there. How do you understand anything by reading that one line? Do you just apply the prison manual to this Article 15 and say that there's a violation, or do you have more of a burden on your part, right? And the way legal argumentation works again is you have to go to the question of precedent, right? You have to find other judgments because the court has interpreted what is the word discrimination grounds of sex or discrimination grounds any of these markers mean, right? And Especially, I'll give you one example which I think some of you are reasonably familiar with, maybe two examples. Uh, One is this case called Anuj Garg, in which women were prohibited from working uh, in at night in an establishment which serves alcohol, and it was challenged on the basis of violation of Article 15. The court held that yes, it violates Article 15 because discrimination on grounds of sex includes discrimination based on sexual stereotypes. The stereotype is that women are a category that need to be protected. You put them in a golden cage, and that's where they need to be, right? And the court said that this is an offensive stereotype. It's a gross and offensive stereotype, and therefore they struck that regulation down. One more example is, of course, the we've talked about this in the past, but I'll mention it again. Is the Sabrimala judgment, right? Why does the regulation which says that women from the age of 10 to 50 cannot go to Sabrimala violate Article 15's prohibition of discrimination grounds of sex? Because the regulation of prohibiting women from the age of 10 to 50 is based on a stereotype. What is the stereotype it's based on? That women from the age of 10 to 50, if they go to Sabrimala, then they'll end up exciting, right? The male members who will not be able to pay obeisance to the deity. And again, the court found gross and offensive stereotypes, right? To on which these rules are based. What is the logic of prohibiting women from the age of 10 to 50? The only logic is Lord Ayappa will find it difficult to handle women, right? And that can't be a logic you have. Take forward in a constitutional court was the way was the logic the court came to. So again, struck down on that basis. One more example of an offensive stereotype is the prohibition on Section 377 of the IPC, which criminalizes what it calls carnal intercourse against the order of nature. Again, that was seen as imbued with gross and offensive stereotypes and struck down as violating Article 15. Right? So again, you get the logic. Then you flow from that to prisons. The flow is clear, right? The courts are very clear. They're saying again, if you have the question that Dalits should only be cleaning toilets, it's a gross and offensive stereotype. Hit by Article 15. Right? So again, this question of stereotype, right, is now part of Indian law. That's the simple point I'm making in this long narrative of cases under 15. Okay, that's 15. Then go to 17. Right? 17 again, the if you go to language, 17 talks about the prohibition of the practice of untouchability. Just look at it. I think it's useful to just. Yeah. Yeah. Somebody just please read it.
Untouchability is abolished and its practice in any form is forbidden. The enforcement of any disability arising out of untouchability shall be an offense punishable in accordance with law.
Yeah, again, I mean, I don't think any of you need to be convinced that if you're having, right, this question of, people from a certain caste cleaning toilets, it is a taking forward of the practice of untouchability. It seems as crystal clear as that, right? And one more point to note over here, which the petition brings up, saying that the one is the constitutional prohibition, second is the most specific, the manual scavenging uh, prohibition, prohibition of manual scavenging and rehabilitation of manual scavengers act, which was passed in 2023. Right? And this idea that you send a person down a manhole in a prison is outrageous, right? From the constitutional sense. And from the point of view of the law prohibits this practice. How can you be allowing this any further, right? So the prohibition of practice of untouchability again, Very clear. Maybe this I'll read out to you. I'll just read out to you apart from the judgment, so you get a sense of what one is talking about, other than just me speaking about it. And of course, you're all going to read the judgment now after this, after me taking you through it. Okay, I think we might as well reference this now itself. Uh, okay, first let's just look at the caste-based practice and look at the stripe thing in a minute. Yeah, just read paragraph 180 or maybe paragraph 179 onwards. Yeah, 179.
Okay, I'll go. The notion that an occupation is considered as degrading or menial is as the is, is an aspect of the caste system and untouchability. The caste system rigidly assigns certain tasks to specific communities based on birth, with the lowest castes being relegated to tasks considered impure or unclean, such as manual scavenging, cleaning, and other forms of physical labor. That a person belonging to such a community is accustomed to performing menial tasks is a mandate of the caste system. Similarly, the reference of scavenger class is a practice of caste system and the untouchability. So, so no social group is born as a scavenger class. They are forced to undertake certain jobs that are considered menial and polluting based on the notions of birth-based purity and pollution.
Yeah, this is 180 as well, please.
Okay. Refusal to check caste practices or prejudices amount to cementing of such practices. If such practices are based on the oppression of the marginalized castes, then such practices cannot be left untouched. The Constitution mandates an end to the caste discrimination and untouchability. The provision that food shall be cooked by suitable caste reflects notions of untouchability, where certain castes are considered suitable for cooking or handling kitchen work, while others are not. Besides, the division of work on the basis of caste is a practice of untouchability prohibited under the Constitution.
Great. Yeah, I think that was quite clear. I think, yeah, whatever I said and what I just said, what the judgment was, judgment in effect puts out. But I wanted you to read it because sometimes reading it sees things a little deeper than one just than when one just says it. So you got the logic of 14 and the question of intelligible differential and objective, 15 and the question of stereotypes, and 17 and the question of the prohibition of untouchability. And 21, let's look at 21. 21 again, what is 21? We're going to just open that provision for you again. Very simple. No person can be deprived of his life or personal liberty except according to procedure established by law. Again, right? What do you understand by life? What do you understand by personal liberty? Is something which obviously this provision itself does not say, but to understand it, you have to go back in a sense to the case law under 21. Right? And since 21 is important, maybe we'll look at the case law a little bit so you get really a sense, right, of how has the Supreme Court understood this question of both life and personal liberty, right? The two ways to look at two points, right? First is where to look at what the case law underlying it is. What is the way the question of protection of life and personal liberty has been understood by the courts till now, and then to apply that understanding to the current fact situation and see that does it violate the protection which the court which the constitution guarantees you to life to your life and personal liberty. Yeah, let's just open the Okay, just maybe I'll just take you a little bit so you get a sense of how you find this is extraordinarily easy judgment, right? In terms of its structure, so it's very easy to find what you're looking for. Others are not so well structured. See, I took you through 14, right? The law on 14. This is the law on 15, the law on 17, law on 21, law on 23, right? And then you go to this question of discrimination, and finally you go to your last part of the analysis, right? How do the implement provisions uh, how are they how do you look at them within the framework of the constitution, right? But first you understand what is the what is the law on the point. Let's just look at we can't look at all of it, of course, but let's just look at 21, right? Again, we've talked about this before. Life and personal liberty now also includes within the framework uh, dignity. And what is, I think, very interesting is that the dignity development, right? Uh, I think we've spoken about this before. The dignity is there because of Ambedkar's intervention. That's one part of the story. But if you look at the development of dignity in the jurisprudence of the Supreme Court, the the key contribution has actually been cases in the context of prisons. Right? Put it more simply, right? Uh, in a very everyday sense, right? You think somebody is in prison, they're like, yeah, that's it, story over. What can be done? That's one ordinary everyday understanding. But the constitutional understanding is this, right? Is that even if you're in prison, right, your rights do not stop at the prison door. You continue to have rights even though you're in prison. Again, what are the rights you have? That we go back to 21 and the question of of dignity in particular. Rather than the question of handcuffing, let's look at the case law on the point and see what do the courts have to say on that particular uh, question, right? And again, the question of handcuffing. Okay, I'll just make a quick point on this. If you look at the jurisprudence, right, on handcuffing, actually, you should just read Krishna on this point. I'm going to take you through Krishna's judgment. Why am I speaking when he said it so eloquently? Okay, so again, see, see, if you read this judgment, right, each of these, you can go back, right? You can actually trace it back and look into what is the area of law, right? I mean, see, for example, one can truly embrace dignity 21, integral aspect of life, sustenance of one being to the fullest. One can fully embrace identity, whether on questions caste, race, gender, sexual orientation, ethnicity, only the given dignity, right? So the idea that your identity is you can fully embrace your identity. You can fully, which what does it mean? You can only fully be yourself, only if you're given your dignity, right? And what is dignity? Dignity is a fundamental sense of self and autonomy, and your 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 right to be treated as a self-governing entity, right? Okay, there's again lots of I think very important thinking on what you mean by dignity, and this is the point which I'm making. The right to live with dignity extends even to the incarcerated, right? And so let's look at yeah, yeah. I think this is Krishna judgment, so I think it's worth reading just that one paragraph. Please just read it. 59.
Did you want us to read? Sorry.
Yeah, please go ahead.
The whole 59, a constitution bench of this court in Sunil Batra versus Delhi administration took serious note of the treatment meted out to under trials, convicts, and those awaiting the death penalty. Justice Krishna Iyer, in his opinion, expounded the humane thread of jail jurisprudence that runs right through is that no prison authority enjoys amnesty for unconstitutionality, and forced farewell to fundamental rights is an institutional outrage in our system where stone walls and iron bars shall bow before the rule of law. He emphasized the need to relook at the prison conditions. A prison is a soundproof planet, walled from view and visits regulated. And so rights of prisoners are hardly visible. checking is more difficult, and the official position of the repository of power inspires little credibility, where the victims can be political protesters, unpopular figures, minority champions, or artless folk who might fail to propitiate arrogant power of minor minions.
Yeah. So this is you got a full taste of Krishna jurisprudence or Krishna's style of writing, which quite I think we look notice. I mean, we can do a literary analysis, right, of his love for alliteration, right, from minor minions to
Yeah.
post farewell to fundamental rights. It's great. I think it's great actually. His, although I'm sure Saila will disagree. She'll be like, "What is this? Why are you getting excited about this?" Slightly over the
Stonewall
top language.
bars shall
Yeah,
both before the rule of law.
yeah,
That's very interesting.
yeah, yeah. Yeah. So this is okay. Your bar fetters, Mr. Shantan. Here's your point of bar fetters. Please read it.
Yeah, I can read. I hold that bar fetters are a barbarity generally, and like whipping, must vanish. Civilized consciousness is hostile to torture within the walled campus. We hold that solitary confinement, cellular segregation, and marginally modified editions of the same process are inhuman and irrational. More dangerous are these expedients when imposed by the unturned and untrained power of a jail superior who has, as part of his professional equipment, no course in human psychology, stressology, or physiology, who has to depend on no medical or psychiatric examination prior to infliction of irons or solitary, who has no obligation to hear the victim before harming him, whose quote unquote reasons are in English on the history tickets and therefore unknowable, and in the journal to which the prisoner has no access. The law is not abracadabra, but at once pragmatic and astute, and does not surrender its power before scary exaggerations of security by prison bosses. Social justice cannot sleep if the Constitution hangs limp where its consumers most need its humanism.
Wait,
Beautiful.
I think you'll need some time to absorb this. I think I can't just go on after that intense. What? Bar fetters are a barbarity. Again, look at a civilized consciousness, right? And the way he's able to communicate, right? The 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 problem with prison. Again, see, though the language is sometimes a little strong, but the points are very important, right? A prison is a soundproof planet, wall from visits. Again, very, very important point which is being made here, right? And the criticism you'd have, right, of the Krishna judgment, which is in Sunil Batra, is what did it finally do? All this is it will be Sila's point. I'm just since she's not here, I'm just trying to ventriloquize and think what she'd have said. So, Arvind, all this is great, fantastic language, etc. But what finally happened in Sunil Batra, right? It's a very important question, and the answer you have is that the the prison rules which govern uh, prisoners is not struck down, but is read down to prohibit solitary confinement, right? So they're not saying this is unconstitutional. The rules are unconstitutional. In the practice, you can't keep people in solitary confinement. That conclusion that the courts come to, right? So again, it's a conclusion in terms of not a striking down of a rule, which is an important point to keep in mind because in this judgment, right, they strike down rules. The rules which we refer to, all the rules which are entered, they struck off. They're not there anymore. Whereas here, the rule is there, but you can't utilize it to carry out solitary confinement. So there's a way in which the relief question is, I think, is very different in this case compared to Sunil Bhatt. The rhetoric point in terms of communicating a point forcefully and strongly, I think both are quite forceful and strong in the way they communicate the point. Okay, but yeah, let's go on to what are the we yeah, yeah. I think this is a, yeah, Krishna again. I think we should just read this last paragraph, please. Last paragraph. Krishna held.
I'll read.
Please, please.
Prison houses are a part of Indian earth, and the Indian constitution cannot be held at bay by jail officials dressed in a little brief authority. When part is
3.
when part 3 is invoked by a convict. For when a prisoner is traumatized, the constitution suffers a shock. Whether inside prison or outside, a person shall not be deprived of his guaranteed freedom, save by methods right, just, and fair. Prisoners are peculiarly and doubly handicapped. For one thing, most prisoners belong to the weaker segment in poverty, literacy, social station, and the like. Secondly, the prison house is a walled off world which is incommunicado for the human world, with the result that the bonded inmates are invisible, their voices inaudible, their injustices unheeded. So it is imperative, as implicit in Article 21, that life or liberty shall not be kept in suspended animation or congealed into animal existence without the freshening flow of fair procedure.
Yeah, no, as I'm reading this again, I'm realizing that he really does love alliteration, no? Look at the last unfreshly flow of fair procedure. He's totally
Yeah.
into rhetorical, communication. So I think, but yeah, this is a good point, a good point, a bad point, but it's a point, which is that who are judgments meant to communicate with, right? One view is judgments are meant to communicate with lawyers. The other view is judgments are meant to communicate to a wider audience, right? If it's a wider audience, this is the kind of rhetorically powerful language that is very important and very useful in any advocacy you're doing in prisons, right? In any work you're doing in prison, this is what you need to be able to draw upon to make your case, as it were, right? And because a lot of very important points are being made in very, I think, very strong and very powerful language. Okay, so we won't. I'm not going to take you through any more on the uh, 21 case law. But just to keep it with you, that the broad the broad point is that 21 includes a guarantee to the right to dignity. Right to dignity is something prisoners have. That is, even when talking about a procedure established by law which can restrict your rights, the right to dignity is something which is so fundamentally part of who you are that even prison cannot restrict your right to dignity, even prison, right? And that's a very, very important kind of a conclusion which you have, because look at the language of 21 again. No person can be deprived of his life or liberty except by procedure established by law, right? So, can you have a procedure established by law which can deprive a prisoner of his right to dignity, right? And the court's finding in all these cases is such a law will be substantively unjust, and such a law will not pass the muster of the Constitution. Going back to our case, right? If you ask the question, how does this violate 21? Again, I think by now, if you read the prison rules, I don't need to convince you. Of course, the when you when you're classifying shall we say occupations based on based on based on sorry, classifying based on caste, you are hitting at people's dignity. Again, the dignity question, right, is very, very useful. Again, in this judgment, is very, very usefully linked to the question of individuality, right? When is your dignity hurt? Your dignity is hurt when you're treated as part of a group, regardless of what your individuality may be. When there's no respect for your individuality, I come into prison, you belong to a certain caste, therefore you do this job. Cleaning toilets is your job, and that's an offense to your dignity because your individuality is not recognized. Who you are as a human being goes out of the window when you're sought to be captured within a caste-based practice, which is what the prison rules allow for. I think this language, I'll just find that language for you, which is, I think, useful in page 122, I think it is. 1 second. Yeah, yeah, this is exactly what I was saying, but just read it again. Paragraph 187, please.
Article 21 envisages the growth of individual personality. Caste prejudices and discrimination hinder the growth of one's personality. Therefore, Article 21 provides for the right to overcome caste barriers as a part of the right to life of individuals from marginalized communities. The protection provided by Article 21 can be seen as a constitutional guarantee that individuals from marginalized communities should have the freedom to break free from these traditional social restrictions. It extends beyond mere survival to ensure that they can flourish in an environment of equality, respect, and dignity without being subjected to caste based discrimination, which stifles their personal growth.
Yeah. Again, see, we can read a range of paragraphs here, but we'll stop with this one paragraph. And just to, right, okay, maybe I think just read the one more paragraph. I think it's useful. Yeah. 188.
When caste prejudices manifest in institutional settings, such as prisons, they create further restrictions on the personal development and reformation of individuals from marginalized communities. When prison manuals restrict the reformation of prisoners from marginalized communities, they violate their right to life. At the same time, such provisions deprive prisoners from marginalized groups of a sense of dignity and the expectation that they should be treated equally. When prisoners from marginalized communities are subjected to discriminatory practices based on caste, their inherent dignity is violated.
Yeah, I think it's quite powerful the way the again the if you want to put it the Chandrachud prose style compared to the Krishna prose style, right? Where the point is made uh, quite strongly, where you're making the point that again institutional settings are create even further restrictions. Right? It's not easy to be in an institution setting. Going back to the Krishna language, it's like a soundproof planet, right? And caste prejudices in a soundproof in the soundproof planet will really create further restrictions on the personal development and reformation of individuals. Right? So again, the question of dignity is central. Again, the simple point which the judges are making is that when you when you reference the question of dignity, the prison is not a dignity-free space. You have to be Your dignity has been respected, even if you're in prison. Prison gates are not the point at which the discourse on dignity stops, right? So that's the broad kind of a point on 21, which I think comes through quite quite powerfully. So I think we have one more article which I wanted to look at, which is 23, and then we'll look at then after that we'll just look at the what the orders the court has given and think where all of this is going, and we'll end with that. Yeah. So I'll take you to 23 now. 1 second. Yeah, if anybody has any question, please you can always stop me.
Yeah, I have a question.
Sure.
So it was shocking to see, how these prison manuals have provisions that the provisions go, I guess, so explicitly like against the Constitution. So, especially Article 15 and 17. So, like, was there an argument or logic which people used to say that those provisions actually like didn't go against the Constitution? And
Yeah, that's a good question.
I guess I guess that like it fit within the framework or permissible within the
That's a
Constitution.
good question because that's the argument is put forward by the petitioners in this case, Sugana Shanta and others, saying it violates these provisions. Your question is, what was the response of the Union of India? Right? How did they respond, or to this particular challenge? Saying, did they say, okay, fine, we accept these practices are discriminatory and we will change them, or what did they do? Right? And so, two things you look at for this: you look at both the arguments of the Union of India and the final ruling. You look at the arguments of Union India and the ruling, you'll get a sense of uh, where this question lies. We'll go to that in just 1 second. Uh, Two more things which I wanted to get done before that, very briefly, uh, is you just look at it again, is the question of 23. Just somebody just read 23:1, please.
Traffic in human beings and begar and other similar forms of forced labor are prohibited, and any contravention of this provision shall be an offense punishable in accordance with law. 2. Nothing in this.
That's fine. Thank you. Thank you. Yeah. So in this case, right? I mean, again, what the judges do, right? Again, it's very interesting. If you read actually, it's a judgment. Again, I go back to you guys. Please read the judgment. The the they on understanding 23, right? They go back to the Constituent Assembly debates, right? And the Constituent Assembly debates again indicates that what was in the mind of the framers was the entire question of forced labor on the basis of caste, right? The fact that caste-based practices, right, are a form of forced labor. Again, begar is a practice in the north where you people are forced to do certain tasks based on the caste that they come from, and as a kind of a customary service. There's no contract. There's no agreement. The only reason you do that because your family members have always performed that particular task. Baker gives an example, right, where if in a village uh, somebody passes away, an upper caste person passes away, then the Dalit person is told, hey, go inform everybody in other villages that this person passed away. So you drop whatever you do and go immediately. Right? So Ambedkar's point again is when you say bigar, it's a form of practice. It's not like a contract. A contract. End of the day, there's timings and there's a specification of tasks, right? Customary labor, which is a form of again going back to the question of forced labor. There's no question of there's no thinking of it within the question of timings or hours of work, and there's no question of thinking of it within the entire question of uh, of tasks to be performed, right? If you're a forced labor as begar, means you're bonded to the master. You do whatever the master asks you to do, uh, and whatever time the master asks you to do. If you're not there for whatever reason, then your other family members, your wife or your children or your grandfather or your father has to do the same task. That's the nature of the notion of begar, which is a kind of all-enveloping notion of labor, which is doesn't have the limit points which contract imposes on labor. Forced labor is bad, right? But begar is worse. That's the Ambedkar kind of a point. That's begar under 20 under Article 23, right? And the initial conceptualization of begar is really in terms of forced labor. Sorry, it's really in terms of caste-based practice, and clearly, this question of caste-based practice continues within the prison. And so, does that amount to forced labor? The judge's argument is yes, it does. because you don't have an option. You belong to the caste, you have to do it. If that is not caste, if that is not forced labor, what is? Right? So there's a again a very straightforward. I think the way I don't think any of you need to be convinced that that what is happening in prisons under those rules is also a violation of 23 and the practice of forced labor or begar. Either of the two terms you can utilize to think of what is going on. Let's just see what the court says anyway. Just read from Rule 26 point. Yeah, somebody please read.
Rule 26.69 of the Himachal Pradesh manual states, if there are no female of suitable caste for conservancy work, paid sweepers shall be taken into the enclosure in charge of a warder and under conditions laid down in paragraph
Sorry. Yeah.
laid down in paragraph 214. Such provisions often lead to an unfair distribution of labor within the prison system, with persons from specific communities performing honorable tasks, while those from marginalized communities are forced into undesirable work. It perpetuates the idea that some individuals are inherently suited to low status labor based solely on their birth, reinforcing deep-rooted caste inequalities.
Right. Okay. So I think by now I think you're all convinced that that these provisions violate 14, 15, 17, 21, and 23. The question.
Arvind, sorry to interrupt.
Yeah.
I can't resist because when was these manual brought out, and was it not brought into light before this case?
Again, a very good question, and that's the same thing I did. As I looked at the year of the manual, right? You saw that Uttar Pradesh was 2022, Bengal was 67.
Okay.
Everything was post 60s. The manuals came into force, right? So it's all very comparatively very. I mean, post constitution, post Article 17 coming into place. So, yeah, and your question of was this not brought into question, right? Again, two answers to that. One is who pays attention to the prison system, right? And who has access to the prison system? Who pays attention? Who has access? Those two questions. Third question is even those who have access. This is a indictment of progressive groups, right? Those who have access, are they conscious of the question of caste? That's a big question, right? The three possible reasons or three reasons why the issue may not have come up till now. Right? That's what I can think of, and speculative, of course, on why it's not come up. And the concrete answer, of course, is we'll have to look at case law and see has it been come up anywhere before. My sense is no, only for the reason that we have a great investigative journalist over here. She's done her research, pulled stuff together, and she's come up with the finding that these rules have never been challenged. So then you look at it and say, wow, that tells you a lot about where we are, right? I mean, as a country, right? And what issues we have not taken seriously till today. So that's the only answer I can give, on that point. And I think, yeah, I'm as shocked as you are. Each time you read it, you're like, wow, this is like incredible. But the fact that it's not being challenged till now, and that's your point. How has nobody challenged it? all these years. But I think, right, the more you go into a range of these questions, the more you'll find. And you'll find again, the point over here is simple. You'll find a particular blindness on the question of caste, right? Across the board. And that's the point which this issue raises very strongly before us. Because again, see, the what you're looking at here is not state versus individuals alone. Right? Looking at almost a system, right? Where some people benefit, other people don't within that system itself. So this way in which the state is complicit in a system of oppression, which is a system of oppression which exists in the wider society. The prison is only a space where the prejudices outside find a certain kind of concentrated force. Right? It's a soundproof planet in which the worst prejudices become a part of this the wider scenario. Okay, yeah. Shandan, you have something to say?
Yeah, I mean, a very quick question. Feel free to take it up later as well, because I think this session was also on social action litigation. So this question comes also related to the previous question. So say a group of citizens, they also see this vagrant uh, sort of breaking of rules happening, even the ones in the prison code, and they approach the prison's authority to sort of take them into notice. Immediately, the procedures are thrown at them. You're a citizen, you're not a lawyer, go to this person, get a permission, go to that person, get a permission. And so immediately it's thrown under the bus. So just sort of saying that even for lawyers or for a group of citizens, even if there is violation of the law as per the code, what are ways to sort of get this point through? What are ways to sort of get the authorities to acknowledge this without sort of mobilizing people or sort of getting a groundswell with orders or anything? Is there an alternative, by the way, for doing that?
See, the again, if you read Colors of the Cage by Arun Arun Ferreira, right? Who's one of the BK16, and he'll tell you how, for example, the first thing they did when they were imprisoned is try and get somehow a copy of the prison manuals. The prison manuals are your constitution, are what you have to work with, and you have to make your case within the prison manual, as far as when you're within the jail system, right? And your arguments with the jail authorities are based on the manual. You say that this is the provision. You can't do this to me because such and such a provision exists, right? So if that is the constitution at the level of the jail, it tells you how vital the reform of those manuals are. It's absolutely vital. The the question you're asking is what can people within within the prisons do? You'll first make your case as to how your rights are being violated vis-a-vis the prison manual itself. I mean, sorry, in non-conformity with the manual. And the second point, of course, is you can always move before the High Court to talk about a violation of your constitutional rights. Right? That's the second possibility you have. How will you be heard? How often can it happen? Those are all questions of strategy, and it could differ from context to context. And here again, it's how many years on the line, right? That finally you have a, and again, this is we're missing both Suresh and Saila here because for the simple reason that the previous range of judgments, strong judgments of the courts on prisoners' rights were all in the 80s, right? With Sunil Batra and Charles Sobrar's range of cases. This is perhaps the, the strongest one in the current years, right? And look at all the judgments from the 80s to now. I'd wager you don't have one on caste. There's only one on caste, right? So it's interesting that it's only recently that this has even come to the surface, as it were. And here, what did it rely on? One more point, of course, going back to the social action litigation. I'm very happily saying, yeah, you file a case, but your point is you're in prison. What case will you file? Which is why the question of the linkage has become very important, right? Linkages out, from the outside, the world outside. In this case, the fact that someone like Sukanya Shraddha existed and could file the case, and she says, I mean, ah, this answers your question. Why is it Sukanya Shraddha? Why is she filing the case? She says that see, it was impossible to get anybody in prison to file because the danger was too high. They couldn't take the risk of filing a case on their own behalf. Right? Again, you go back to the logic of the prison as a soundproof planet, right? You're completely walled in on all sides. You don't have access to the press or the publicity. So it's far more challenging to take forward your rights within prison. Yeah. Sorry, yeah, Mahendra Kumar, anything in particular which you missed? Do you want me to repeat the point? Yeah, the simple point I'm making in response to, you can hear me now?
It's clear to me. Others? Is Arvind audible?
Mahendra Kumar just said that I think I moved a little away from the mic, so perhaps that was the reason. Yeah. So yeah. So we leave it at that and say that it is challenging, and yet it's very important. And once in a while, an opportunity like this comes up and must be taken as and when it comes up. And you never know when the chance will come to raise these issues. So the question of trying to document what is going on in prisons is very vital and very important. And again, the Shanta piece, the core point being made, even progressive groups haven't taken the issue of prison and caste. And have Dalit groups taken it? Perhaps not either, because again, they've got so many issues to deal with currently, right? Without being able to get into the question of prison. So I think, yeah, it's a very important issue. Okay, now uh, one last point which I want to make. Oh yeah, this is the question on what is the opinion of what is the position of the central government, right? We look at that now. Central government, union government, sorry. Okay, I can't find the paragraph, but anyways, I just put it this way that whenever the question of what is the union government's position came up, the union government's response is only one, which is to say that we have these two manuals. We have the Model Prison Act of 2023 and the Model Prison Manual of 19 sorry what was I saying 2014. Yes. Yeah, I think you just read this, please. Yeah, can you please read this?
Miss Aishwarya, but
Yeah.
please go ahead.
No, please go ahead.
Ms. Aishwarya Bhati, learned ASG, has submitted a brief note referring to the Model Prison Manual for the Superintendence and Management of Prisons in India, 2003, and the Model Prison Manual, 2016. It is argued that the 2016 manual explicitly prohibits caste and religion-based discrimination practices. The note refers to some of the relevant provisions.
Yeah, just read these two more.
From the 2003 manual. The 2003 manual in para 2.15.1 states that management of kitchen or cooking of food on caste or religious places will be totally banned in prisons. B. In para 15.22, the manual states that any special treatment to a group of prisoners belonging to a particular caste or religion is strictly prohibited.
2016 manual again. 2016, just these two, A and B.
A. The 2016 manual in para 2.12.4 states that management of kitchen or cooking of food on caste or religious places will be prohibited in prisons. B. In para 17.22, the manual states that any special treatment to a group of prisoners belonging to a particular caste or religion is strictly prohibited.
Right. Okay. Okay. So, what is the finding of the court? Basically, put it this way: the Union of India's submission is we don't think we should discriminate on grounds of caste either. And what we have in place is the 2016 manual and 2023 manual. And the 2016 manual, in particular, explicitly prohibits discrimination on grounds of caste. That's the logic of the argument which they put forward. Yeah. So, what are the court's finding on that? Yeah, just read it 203, please.
Second, the manual does not explicitly prohibit physical caste-based segregation of prisoners, except in prisons for women. Only the chapter on women prisoners provides that no classification of prisoners shall be allowed on grounds of socioeconomic status, caste, or class. This is concerning as the manual was prepared in 2016 when prison manuals in different states mandated caste-based division of prisoners as indicated in our analysis in the previous section. The manual of 2016 therefore should have adopted a specific provision prohibiting the classification of prisoners on the basis of caste for all prisoners as it does in the case of women prisoners. Should I continue?
Yeah, please.
Third, the manual does not prohibit division of work on the basis of caste except in cooking. Para 2.12.4 provides that management of kitchen or cooking of food on caste or religious basis shall be prohibited in prisons. Similarly, for women prisons, Para 26.45 provides management of kitchens or cooking food on caste or religious basis should be strictly banned in prisons for women. In effect, prohibition of caste discrimination in kitchens shall also apply to allotment of work to cooks. However, the manual does not prohibit discrimination on the allotment of work other than cooking. As analyzed, various prison manuals in different states specify different work to people on the basis of caste. The Model Manual 2016 should have taken into account such practices and provided specifically for their prohibition.
Yeah. So, the model manual of 2016, right, is seen as a step in the direction by the court, but not enough, right? I mean, if you're saying if our analysis, the court's analysis, is the administration in prison is caste bound, we haven't dealt with that fundamental nature of administration itself. We only looked at prohibition of management kitchens. What about the entire question, of toilets? What about the entire question of scavenging? Right? What about the rules which already exist? Right? Should not have said something about the rules which already exist. That's the point which is made in 2016. While acknowledging that there's been two steps forward, which is at least prohibition of discrimination with respect to cooking. That much, right? That much. But the point is that's 2016, and then see the yeah what I said, right? I mean, uh, you're not you're not referred to the question of manual scavenging at all, and that's the big question. How can you not reference manual scavenging uh, in your in your in your in your in your model prison manual of 2016, right? Then after that we have 2023, right? And 2023, of course, comes after 2016.1. 2023 is when the Modi government is in power for a number of years. 2016, arguably, it might have been just what began in 2014 might have just continued till 2016, knowing how far things take. So this is a legislation which I think, at least in my mind, indicates the mind of the government in the clearest possible fashion. Right? What does the government think? And why are we referring to model? This is a broad question. Why are we referring to model prison, model correctional services, etc.? Again, the if you go back right to our to what we studied under 245, right? The question of the division of powers, the question of prisons and pastoral institutions comes within the state list, right? So the center can't have a say directly in the administration of prisons. Again, going back to Ambedkar's opening speech, but the ways around that, right? The ways around that. If your legislation is meant to, in pursuance of an international treaty, you can legislate for the entire country, right? And if two or more states request you to pass a law on the point, you can legislate, right? There are ways around that, but point being that why is it model? It's model because states have this power. It's the state's responsibility end of the day. The center can give a frame, right? A way of thinking, and can apply pressure, saying that why didn't you change your state, why didn't you change your law, and push states to be more compliant with their model. But the question, of course, is their model should be compliant with the constitution. What's the point of having a model if it's not compliant with the constitution? And so the test really is the 2023, right? Which is like literally 2 years ago, right? 2 years ago, what did the model the Modi government came up with to deal with the question of prisons? Yeah, read two at a time.
The Model Act does not contain a reference to the prohibition of caste-based discrimination. This is concerning because the Act empowers the officer in charge of the prison to utilize services of prisoners for administration and management of the prisons. Further disabling from labor and continuously refusing to work is a prison offense. The officer in charge should not be given the liberty to discriminate against any group of prisoners on the basis of caste. While the Model Prison Manual 2016 refers to the prohibition of caste discrimination in prisons in several provisions, the Model Act of 2023 has completely avoided any such mention. A provision to that effect should be inserted in the Model Act. It should ban segregation or division of work based on caste.
Yeah. So I think again the kind of almost the shocking finding is, as far as the union government is concerned, it's gone backwards. Whereas in 2014, there was some kind of a recognition of the question of caste discrimination and prohibition of it in certain forms. By 2023, the government becomes caste blind, saying we don't, I mean, in effect, saying it's not our concern. It's absolutely not a concern. There are a range of other questions around this, which is, of course, I mean, how do you come up with a model act, right? When you come up with a model act, do you, should you, or should you not consult with a range of groups who can give you inputs before you come up with your legislation, right? And to my memory, again, I don't remember any being any consultation around the question of this of the Model Act of 2023, and I think it's indicative. This is the important point, indicative of the larger framework within which the government functions when it comes to the question of caste, right? And how does the government view the question of caste and the discrimination on grounds of caste? I mean, every government has been complicit in doing very little, but you'd hope that over a period of time, because of the pressure which governments face, they get more and more sensitive to the question of discrimination on grounds of caste. But in this case, it seems to be the reverse. Where 2016 you had some reference point, 2023 it's a complete kind of a sun. Okay, now we'll finally end. I'm going to just end with this. Is okay. All this is great. What is the final uh, orders which the court?
One
Yeah. Go on.
And one question, if you could just go back to the paragraph. If it's slightly off topic, feel free to let me know and we can, I'll ask you offline. But so when they say that the act empowers the officer in charge of the prison to utilize the services of prisoners for administration and management of prisons, leaving aside the caste discrimination for a minute, is this can this be considered involuntary servitude?
Yeah, that's a good question. That's a good question. That's a great question. So I agree with you. I think, what do you mean by utilize the services of prisoners for administration and management of prisons? That's one way to frame it. But I think the answer to this actually is you have to read the Model Act, 2023, right? Read the Model Act and say when you utilize the service of prisoners for administration and management of the prisons, what do you provide to the prisoners? If there's something you provide, I mean, in terms of financially, then it's a slightly different scenario. If you don't, then of course it falls squarely right within the prohibition of forced labor. My sense is it will provide something for the service of prisoners, but again, we should check this. That's a good question. We can check this out. Yeah? You please check it out next class, and maybe we can just talk about it in the final session. Yeah.
Okay, thank you.
Okay. Now let's get to the final part after all this. After all that we looked at is the orders. I'm not going to look at the criminal types habitual offenders question because we don't have the time currently. We don't have time currently. Uh, Paulo Freire, okay, that guy's again. Paulo Freire, you have to find and read it on your own. Yeah. Okay, let's see what. Find this is important because okay, all of this is done, all of the analysis we've done. What finally happens, right? Let's just read them in what the final orders are, one by one.
In light of the discussion, we issue the following directions. The impugned provisions are declared unconstitutional for being violative of Article 14, 15, 17, 21, and 23 of the Constitution. All states and union territories are directed to revise their prison manuals rules in accordance with this judgment within a period of 3 months.
Yeah, just on point one, right? Where the conclusion goes to is saying that the provisions which we looked at, the rules we looked at, which all of you guys are so shocked by, all of those have to be now are unconstitutional, right? And so the all states and union territories now have to revise the manuals and rules in accordance with the judgment, right? That's a very clear kind of a finding that they're unconstitutional, not read down, they're unconstitutional, right? And the prison manual and rules have to be revised now within 3 months. Yeah, okay. Point two.
The Union government is directed to make necessary changes, as highlighted in this judgment, to address caste-based discrimination in the Model Prison Manual 2016 and Model Prisons and Correctional Services Act 2023 within a period of 3 months.
Again, the question you'll asked, right? On the model prison manual and the caste blindness of the model prison manual, that they're directed to address the question of caste blindness in the model prison manual. Okay. 3.
References to habitual offenders in the prison manuals or model prison manuals shall be in accordance with the definition provided in the habitual offender legislation enacted by the respective state legislatures, subject to any constitutional challenge against such legislation in the future. All other references or definitions of habitual offenders in the impugned prison manuals or rules are declared unconstitutional. In case there is no habitual offender legislation in the state, the union and state governments are directed to make necessary changes in the manuals or rules in line with this judgment within a period of 3 months.
Yeah. This again, I think we'll have a longer discussion on this, but just keep in mind that the law conceptualizes what are referred to as criminal tribes as groupings which are addicted to the systematic commissioning of non-bailable offences. Criminal tribes legislation is repealed, post which the state enacts the Habitual Offenders Act. And the reference point here is though the law is gone, though one law is gone, now criminal tribes are seen as habitual offenders. So the vague language of habitual offenders becomes used to target criminal tribes. So that's the reference point in, as far as three is concerned. Four.
The caste column and any references to caste in under trial and or convict prisoners' registers inside the prisons shall be deleted.
Again, the entire discussion we had, right? If you go on the Article 14, I mean, any information you have is you're using it to classify prisoners. So why is caste relevant to classify prisoners other than to carry out or other than to engage in practices which violate the constitutional provision? So caste should go. Simple kind of finding of the court on this case. Yeah.
The police is directed to follow the guidelines issued in Arnesh Kumar versus State of Bihar 2014 and Amanatullah Khan versus the Commissioner of Police Delhi 2024 to ensure that members of denotified tribes are not subjected to arbitrary arrest.
Yeah, this is the issue we didn't get time to really look into again. But again, I urge you to read the entire judgment. The question of the though they were initially criminal tribes, then they were denotified. They still are called denotified tribes and are still subject to intensive police surveillance and harassment. And so the question of that this is an attempt to try and put a block or to try and bring this question of harassment within the frame of the constitution by saying that these two judgments should be followed by the police. Yeah. 6.
The court takes suo motu cognizance of the discrimination inside prisons on any ground such as caste, gender, disability, and shall list the case from now onwards as in discrimination inside prisons in India. The registry is directed to list the case after a period of 3 months before an appropriate bench.
Again, this is a very important provision because you get a sense, right, that this issue is not over. That's what the court is telling you. They're saying that of course, we understand that a range of things happen within the context of prison walls, and not all of it may work within the framework or the limits imposed by the Constitution. So they're saying that we take suo motu on our own. We take cognizance of the discrimination inside prisons on any grounds, such as caste, gender, disability, and shall list the case from now onwards. So you're supposed to have, as per this judgment, a continuing case in discrimination inside prisons in India, right? And once it's listed, again, there's an opportunity for everybody can file interventions or impleadments within this case and bring the attention of the court to forms of discrimination on these grounds or other grounds. Uh, yeah, as and when the case is listed. As far as I know, that's not case is not listed as it. Yeah, we'll end with that. I think the other two you can read later. That is it. Yeah, from my end.
Arun, can I ask a question?
So,
What does it mean to when you say the case has been listed as discrimination in the prisons? Is it going to be like an ongoing?
yeah, what the order the court has given again is very interesting. Is the saying what in effect they're saying it should be an ongoing matter. An ongoing matter looking at discrimination not only on grounds of caste but also of gender and also what are the other markers they use? 1 second, let's go over to
Disability also.
Let's see. Caste, gender, disability. Right? They've not used religion, but they've not on grounds such as. So it's really up to the bench. If you have a sensitive bench or bench which wants to take it up, they can include other grounds as well, right? Caste, gender, disability, and other grounds, and list the case from now onwards as injury discrimination inside prisons in India. This is the case after a period of 3 months, right? But the question is after a period of 3 months, uh, not before, but after. So after a period of 3 months could extend indefinitely. I mean, we don't know when they will list it. I mean, that's the only point. And this is a judgment, of course, by the then Chief Justice, who's obviously keen on it. He's not there anymore. So when will it be listed? We don't know. But I think this is again worth keeping in mind. And again, it's worth putting filing applications, asking that it be listed, right? And that's a point which might be worth following up on because it's a great opportunity. I think take this matter. But that's my two cents on the point. Yeah, any other question we can take and then. Okay, great then. I think we can.
I had a question.
Yeah, go ahead.
So, in instances of caste-based discrimination, I understand that a writ petition can be filed. So here the government was responsible for an institution, right? So we could file a writ petition. But what about instances of untouchability in daily life? What can be done there?
See, you have to understand what the court can do and what the court can't do, right? The question of discrimination on untouchability in daily life, right? There's a legislation on the point, which is called the Atrocities Act. So you can utilize that particular legislation and file a complaint. That's the technical legal answer. That's what you can do, right? So it's covered as per through a legislative. Uh, the gap is covered by legislation, or the issue you're raising is covered by legislation.
Okay.
I know you're not satisfied, but that's what you can do. I'm not saying it always work, right? It's a
Right. And so here the journalist was a third person, right? So in the Atrocities Act also, it can be a third person filing a writ petition.
yeah. See the FIR, right, can be filed by any person who has who 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 can reasonably come to a reasonable conclusion that an offense is being committed. The person who's being violated is not the one who needs to file the complaint.
Got it. Yeah, thanks.
So there are a set of three related questions. They're in the chat. I can just read them out as well.
I'll read, no problem.
Go ahead.
Gitakshi's point, right? First, is that the first one? Yeah. Yeah, that I agree with. No disagreements on that with Gitakshi. And I guess the point is, how do you take the meaning of a judgment to a wider public? That's the question you have, right? And in a sense, I guess the fact that we're talking about it in this class, nobody knew about it, my understanding, till we spoke about it in this particular class, right? So there's a really crying need for communicating the meaning of a judgment to a wider public, right? And that's very, very important. Again, when we say constitutional literacy, it's not just about the provisions alone. That's a point to keep in mind. It's as much about judgments and how judgments take forward the meaning of the Constitution. And I leave it as a question back to you, as in how would you take forward the meaning of this to wider public, right? How do you take this to wider public? Is there a campaign you build around it? Is there awareness you build around it? what can you do, right? That's a question which I think we all have to face. Mike's question. Uh, good question. The prison officers and police officers have teaching training includes a part of the Indian Constitution relevant to the rules. Again, we miss Suresh on this point. He'd be able to answer the question because he's done a range of these trainings on whether they do have. Uh, See, the judges, for example, the Judges Training Institute and judges get trained, are supposed to get trained in developments in law, constitution, etc. Right? And, and police training, for example, uh, some of our colleagues are engaged in doing police training. Police often call upon, NGOs, etc., to do the training. So it's really up to NGOs and the understanding and what they're able to take forward. And what I have understood, it's always very challenging to refer to the Constitution in the context of the police. Police are like, okay, tell us what the Criminal Procedure Code says. Tell us what the IPC says. Why do we need to know what the Constitution says? That's a challenge which is often faced. But how do you get past that resistance? Is really the question. Okay, then the next question is Satya. What is the difference between SAL and PIL? See, that's a Bakshi kind of a distinction, and you can put it this way: the public interest litigation can be filed with one person on behalf of a group. A social action litigation will be the group taking the issue up for itself. Public interest litigation will be like me on your behalf. It may not particularly empower you. The social action should be a litigation process which empowers you to take take litigation to take to take your rights forward. The public interest litigation will not be concerned with what goes on outside the courts necessarily. Social action is just you understand that change is a complicated process. It's about working inside court, working outside court, and it's about bringing into being an activist community which can continue to do the work even when you are no longer there. PIL is about can be not always is about the person filing the PIL. SAL is about the group on whose behalf the group which is advocating its issue for itself, right? So there's uh, an important distinction to keep in mind. And again, the I suggest you just read the article again, the Bakshi piece. He'll explain it. You really will get a good sense of what I'm trying to say in my own way.
We have just 3 minutes left. Any last questions? Else we can call it a day.
Just Satya here. In Bakshi, he says he prefers to call it SAL than PIL. He doesn't define them or say how they differ from each other. He
Thank you.
says, I prefer.
You're right. You're right. You're absolutely right about that. So I'll circulate to you another. Actually, we had done a conversation with was a Bakshi called "Of Law and Life." Right? It's a long conversation with him, in which he expounds, explicates this particular point. So I'll get those pages for you and give it to you. And sorry, and send it to Shantanu. He'll circulate it to everybody, and that will clarify the point. But you're absolutely right. You read the article closely. It does not make that critical point of what is SAL, other than saying he's calling it SAL. So you get a sense that, I mean, in fact, to be honest, or to be the question you're asking, right? I didn't understand. I've known him for the last how many ever years. I never understood why he's saying SAL. But I thought maybe it's a kind of pedantic point and it doesn't mean much. Only recently I realized the significance of him making that particular point, right? So I'm glad you asked the question much earlier than I did because I kept quiet for how many ever years since he's been speaking, and only now I'm like, hey, you're not explaining it in your article. So can I ask you? Can you tell us why? What do you mean by SAL? So I'll send you that piece so you can look at that.
Thank you so much.
Okay, thank you everybody. I think on that note we can wind up. And if you haven't yet had your dinner, you can please go ahead and have your dinner. I guess you don't need my permission, but I think yeah, you can go and have your dinner now. Okay, bye everybody.
Thanks, everybody. Bye bye. Have a good night.
Thank